All right, you've been in an auto accident, injured. It's not your fault. The other driver's fault, and you happen to have your minor child in the car with you. Child under 18 years old. Child's injured as well. You eventually come to an agreement to settle your injury case with the other driver's insurance, and then you make it to a point where you want to settle your child's case. Is it as simple as just having the insurance company issue a check as the parent? Simply put, no. There's a pretty involved process to settle a minor's injury claim, and it involves filing an application with a probate court in the county where the child resides. And the process differs. There's two different processes, and it depends on the net amount of the settlement, the actual dollars that are going to go to the minor child. For settlements of $25,000 and less, there's one process, and then for settlements above $25,000, it's a little more involved. So let's start for settlements $25,000 or less, and this would be the net amount that would go to the child. So out of the personal injury settlement, you're probably going to have attorney's fees paid, some additional costs to get medical records. If there's a lawsuit filed, there might be some court filing fees. And then there's the subrogation of health insurance paid, some medical expense. That health insurance is going to get some reimbursement. So we're talking about what the child is going to get after all those fees and costs are taken out, $25,000 or less. And what one of the parents is going to have to do is file an application to settle the minor's claim. And one of the parents will be what's called the applicant. And the applicant is, simply put, the person asking the probate court to approve this settlement. So there's a standard form in Ohio for this application, background information about the child, the parents, the date of the injury, nature of the injury, the amount of the settlement. This application will you'll have to include a narrative of what actually happened, what available insurance there is. There'll have to be a narrative from the child's doctor, either separately prepared or just medical records if all the needed information is in the records. And we're talking about the injuries, the diagnosis, the prognosis, if there's some permanency, addressing the permanency of the injury. In addition, if there's an attorney involved, there's going to need to be an application to approve the attorney fee that includes a copy of the written fee agreement. The probate court ultimately will have to approve the attorney's fee. And most times both parents are on board, so they will consent to this application, consent to the settlement and distribution, and a parent won't have to be served with notice of the application or any hearing that would be included. Sometimes a parent may not be involved or may not be part of it, so if that's the case, a notice of the application to the non-applying parent will have to be submitted. All these documents will be submitted to the probate court. There's a filing fee. In addition, the court will require a certified copy of the child's birth certificate. I know here in Medina County, I think they require a birth certificate that's been certified within the past few months, so it's quite possible you would need to go to the Department of Health to obtain a new birth certificate. Once all these documents are filed and a filing fee is paid, the court will set it for a hearing. And this hearing will usually be maybe about 30 days after the application is filed. The parent, who is the applicant, has to attend, the minor child has to attend, and if there's an attorney involved, the attorney will attend. And at this hearing, either the judge or the attorney will question the parent just to make sure that she or he wants to approve the settlement on behalf of the child. Make sure that the parents know once the settlement is approved, they will be releasing the insurance company from any further liability on it. So it's just a way for the court to confirm that yes, that this is best for the child and this is what the parent wants. Then court will issue an order approving the settlement, and the next step would be to open a bank account in the name of the child, probably a custodial account. Once the check is available, the parent will take that check to the bank, deposit it, and there'll be a probate form for the bank to complete, a verification of receipt and deposit. Bank completes this form, then this form has to be filed with the court along with a report of distribution, which ultimately just shows how all the funds are distributed. This is the gross amount of the settlement, attorney's fee and X amount paid, costs paid, subrogation lien paid, with balance to the minor. So that's filed with the court with the verification and receipt of the deposit. And then what the parent will have to do on an annual basis, file a verification of the account, just showing the amount of funds that are in the account. And again, this is a form that the parent would take to the bank. The bank would complete the form, and then the parent would file that with the probate court. So that's the process for settlements of $25,000 or less. As you can probably tell, it's a pretty involved process, pretty detailed. When it comes to settlements in excess of $25,000, it's the same process that I just went over, except that the parent will have to apply to be appointed the guardian, and this would be a guardian over the estate of the minor. So the parent would be guardian over these funds that the minor would receive as a result of the auto accident. And so it's a little more detailed. There's an application to be appointed guardian, a next of kin form, which basically lists all the parents and perhaps siblings. Sometimes court may require a background check just to verify that the parent isn't someone who may try to run away with these funds, steal these funds, misappropriate the funds. And so it's a little more detailed. There may be a little more of an in-depth hearing other than just questioning the parent to make sure that the parent wants to approve the child's settlement. And really the reason behind this just is to make sure that the child's best interests are being looked after, making sure a parent isn't going to misappropriate these funds, as I had just said. And so the court wants to follow this more formal process when we're talking about some much more substantial settlements that may go to a minor child. And then with regard to the guardianship, the accounting of the funds is a little more in depth. It's not as simple as just getting the bank to complete a form. The guardian would file an account that shows all the receipts and all the disbursements. So say the money's put into a savings account. This account's going to show each and every interest payment on the account. So it's a little more detailed than just the verification of account for settlements under the $25,000. Once this is all complete and you got money in the bank for your minor child and you want to use it for some expense, whether it be medical expense, education related expense, or I don't know, vacation, anything that you could think of that you would want to use the funds for the child, it's not as simple as going to the bank and withdrawing the funds. You gotta file an application with the probate court to expend funds. Court will, in all likelihood, have a hearing on that, and then it'd ultimately be up to the court to decide whether to approve withdrawal of funds for whatever purpose is requested. So the probate court is going to oversee minor settlements, make sure that funds aren't misappropriated, make sure that the best interests of the child are looked after. And that's the process for approving a settlement for a minor child's injury case. It's pretty involved. It's not simple. It's something we do as part of our services for personal injury cases because we know that our clients really don't know the process and it could be a little too much for them, and we're always happy to help.